I was thinking about this conversation I had-ish with Mr. Freeman where he was complaining that he hadn't heard from his lawyer. And I have time today. Obviously, it's Sunday, Memorial Day weekend. I'm not working or dealing with customers or anything like that, clients, what have you. And so I figured what I would do is I would do a little legwork for Mr. Freeman. And I Googled up Mr. David Antonio Woodruff, and I came across this phone number for him in Dallas, Texas. That phone number for him looks surprisingly similar to this phone number for the Dallas County Public Defenders, located in the Frank Crowley Courts building, which he may be familiar with, or may not, I don't know. So, anyway, Mr. Freeman, if you see this, please call the Dallas County Public Defenders at area code 214-653-3550. Obviously, I'm only doing this to point out how stupid and retarded you are, and I'm not in any way, shape, or form attempting to help you get the representation that I think you need and deserve. So, don't take this for anything altruistic. I am literally just being an OG troll. And to prove that, we have this comment. I was actually looking for Mr. Freeman's comments in here, and I could not find it, so he may have deleted it, and that's fine. It's his comment. He's more than welcome to it. However, I did find this comment from Humphrey Pushcart. Now, I don't know why YouTube doesn't tell me about all of these comments, because I enjoy interacting with you guys, for good or bad. You might notice that I will pin certain statements that maybe don't speak very highly of me. And that's fine. Like, I find this to be all laughable and enjoyable. This is fun. I don't make any money off this. I do this for my own pleasure, entertainment, and, hopefully I educate some of you folks. If not, then there's only so much you could do. But Mr. Humphrey Pushcart, with his dubious knowledge of the federal government and the structure thereof, states that actually the government, or the agency responsible for the protection of federal facilities, is the Federal Protective Service, not the U.S. Marshal Service. Now, nowhere in the video there's stupid, and then there's this, that I state that the FPS, or that the U.S. Marshals is tasked with protecting federal facilities. And I could point out that the FPS is only tasked with protecting the GSA federal facilities. I won't do that. And obviously I didn't just do that. What I pointed out, though, is that the U.S. Marshal Service are tasked with protecting courts. And them being around courts should be, they're tasked with protecting federal courts, because they are a federal agency. This is the U.S. Marshals Service, www.usmarshals.gov. This is their duties. The major responsibilities of the U.S. Marshals Service. What's the very first thing they are tasked with? I wonder what it could possibly be. Could it be protecting of courts? No. But let's return to Mr. Pushcart's analysis to get further enlightenment. He says there is an updated DHS memo that covers in detail photography in federal facilities found here. The FPS Photography Bulletin 8-2-2010 redacted. Please, Lord, let it be. Let it be. It's the 2010 memo. He's so cute. He's so cute. Someone just pinch his cute little cheeks. That said, federal courts have had a ban on photographs since the early part of the 20th century. You can read about the history of cameras here at www.uscourts.gov/about-federal-courts/cameras-courts. Or you could get it straight from Humphrey Pushcart the Magnificent. He says, additionally, the chief judge of an individual district is free to set the local rules as expressed in a court order regarding the use and or prohibitions at any property where court is held. Maybe. I don't know exactly what he's saying there. I do know that there are federal rules against cameras in courts. The Ninth Circuit has a pass. There's the judicial canon. There's Federal Rule of Criminal Procedure 53. Fitted tree? Oh, please don't be wrong. Courtroom photography and broadcasting prohibited. God, I'm good at this. I should be an attorney. Yeah, the court must not permit taking of photographs in the courtroom during judicial proceedings. Yeah, so there are actual laws. This is incorporated into 18 USC. Yeah. So yeah, there you go, etc. So yeah, there are rules. There's the judicial canons that they mention in the history of cameras in court. Oh, there it is, Rule 53. I should have read my own source. Yeah. Here's the there's the pilot for the Ninth District. California, Northern, Washington, Western, and Guam. They get to continue the pilot program. So yeah, it's do they say? Yeah, it's the Judicial Conference. I thought it was the Judicial Canon. Interesting. Anyway, yeah, so, well, there you go. I learned something new. Generally, these local rules are posted at building entrances, providing notice before the threshold of the affected property is crossed. That's a good point there, Humphrey. I'm glad you're learning me up something good. Listening to the video, the DHS FPS officer appears to be familiar with the 2018 memo update. He does. Amusing, the marshal's office has a publicly accessible reception area, and there's no standing court order prohibiting. Assuming the marshal's office has a publicly accessible reception area, and there's no standing court order prohibiting recording, then the overlying regulation, conduct on federal property, applies. Of course, the only prohibition of photography is found at 41 CFR 102-74.420 regarding news and commercial purposes. Oh, my dear sweet boy. My dear sweet boy, let's look at it. First of all, we know there is a court there. And we know that federal court does prohibit on its floor photography. And they may extend it to the whole Crowley, or what was it, the Earl something or the other building? Earl Good or whatever. I don't remember. It was some silly name. Let's see. God, I even linked it for him, and he's still telling me about it. I love people like this. They're just autistic as hell. He probably just has this on a Earl Cabell. He probably has this all printed out and typed up, ready to go, just to smack it down on it. This is conjecture, obviously, but he probably has all this ready to go for minor alterations. So yeah, they could extend it to the whole. Oh gee, I just looked at it. Earl Cabell Federal Building. But yeah, so there is a court order standing on the floors where the courts are, and the tenant agency also gets to say no, because you do have to have permission of the occupying agency, Mr. Pushcart, or written permission if it's for commercial purposes. He says, listening to the video, blah, 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 blah. Okay, so moreover, I believe that Freeman is in Texas. He is. And there is an appellate decision binding on the 5th District courts. Is it? Arising out of the Turner v. Driver case. So Turner v. Driver, the courts held that the courts couldn't prevent filming in courthouses? No, they didn't. No, they didn't, Mr. Pushcart. You're retarded, and you should stop. He says, in Texas, 2 maxims exist. Maxims aren't law. So you can take your maxims and make pads out of them. You could make maxim pads. And you could make those maxim pads on legal paper, so they'd be legal maxim pads. And then if you attached, well, we won't attach wings to our legal maxim pads. Anyway, so yeah. No, Turner v. Driver does not say that courts can't restrict filming. Turner v. Driver dealt with the right to film the police in public. The right to film the police in public. And public has a meaning in First Amendment cases, and what their meaning is the right to film police in traditional public forums. It doesn't mean there is no right. So the Supreme Court trumps Turner v. Driver, and the Supreme Court has said that courts can restrict filming in the courtroom. And that goes all the way back to 1964. That case was a Texas case. It was somebody v. Texas. Texas v... no. Oh, God. What is his name? Texas Supreme Court film in courthouse. It was broadcast. It was broadcast in courthouse. Television. Oh, come on. Oh, could it be? Could it be? Estes v. Texas. Thank you. I was thinking it was an A for some reason. Yeah, Estes v. Texas, I said 64. It's 1965. My bad. I'm retarded.
Oh, that means I hate myself. I have beef with myself. I call myself retarded. Everybody freak out.
Yeah, so there. I knew it was a cannon. Anyway, yeah, the Fifth Amendment trumps your First Amendment right to film in courts, but I'm sure Mr. Pushcart was very aware of that. He says, believe me, I am not a Freeman proponent in the least, and that several propositions are the muse of sovereign wingnuts. However, assuming the video is honest and not edited, admitting key content coupled with the FPS officer's demeanor, Freeman was likely in a safe harbor positing his request. No. He was asking the FPS officer to protect him from U.S. Marshals while Freeman committed a federal crime. He would be violating 41 USC 102-74.420, the maximum penalty for violating this regulation is up to 30 days in jail and up to a $5,000 fine. So it's pretty stupid. It's pretty ridiculous to ask a federal officer to protect you while you commit a federal crime from other federal officers. He was not in a safe harbor. And I don't believe that even had the FPS officer conducted him up there, that anybody would have allowed him to film in there knowingly. So thank you, Mr. Humphrey Pushcart, for enlightening us all as to what you've enlightened us to. I'll leave that to your imagination. Thank you all for watching. And in case anybody forgot, Mr. Freeman, your attorney, call him at the Dallas Public Defender's Office, Dallas County Public Defender's Office, at area code 214-653-3550. If you need to remember his name, it is David Antonio Woodruff. 17 years of experience in criminal law in Texas. He may be competent, although I would not much like that he forgot about you 3 years ago. Anyway, have a great day. Thanks for watching.